Dealing with disciplinary issues can be daunting, but when handled properly, disciplinary procedures can help to resolve issues before they become problems. Once an investigation has been initiated and the decision has been made to hold a formal disciplinary hearing, you should give the employee reasonable notice of the interview. In less complex cases, it is advisable to give at least 48 hours notice, whereas a more complex case may require longer. Make sure you arrange the meeting at a time and place that is convenient for both the manager and the employee.
So thank you for coming in today. Firstly, can I just confirm that you've received the letter that we sent inviting you to the meeting?
I did receive the letter, but I don't agree with the allegations.
Well, that is what we're here to discuss, so don't worry, you will have an ample opportunity to put forward your version of events, okay?
Ensure the invitation to attend the disciplinary hearing is made in writing. The letter should explain that the meeting will be held in line with the employer's disciplinary procedures, which should be enclosed. Clearly state all the allegations that will be discussed. Include supporting evidence and information from witnesses, such as witness statements. State the potential outcome. This could be formal disciplinary action, or dismissal, or indeed no further action. Inform the employee they have the right to be accompanied by a work colleague or an accredited trade union representative. The employee is responsible for arranging their own companion. Where applicable, explain if the employee intends to call relevant witnesses, they should give advance notice.
So let me explain why we're all here today and the format of the meeting. I'm Caroline Hughes, branch manager, and I'll be chairing this disciplinary meeting today. With us is Jennifer Hodson. She'll be taking notes for our organisation, but of course she will remain completely impartial throughout.
It is advisable to have a note taker present so they can record at least the salient points from the meeting on behalf of the employer. The employee determines the role the companion plays. They can either represent the employee or simply act as moral support.
Marie Turner is here to act as your companion, and let me remind you what Marie is allowed to do. She can put forward your case, she can confer with you during the meeting, respond on your behalf to any views expressed, and sum up your case if you want. Marie doesn't have the right to respond to any questions that are put to you if you don't want her to. And of course, she can't prevent me from speaking. Okay, is that all clear?
I think so. Yes, I understand.
Marie, can I just check that you've got the appropriate trade union certification?
The trade union official can accompany the employee even if the employer does not recognise the union. An employee is not obliged to act as a companion and may refuse the request. Unless your procedure provides otherwise, an employee may not bring a friend, solicitor or relative to the meeting. If an employee requires specialist support, it may be appropriate for them to be accompanied by someone other than a work colleague or trade union representative. For example, an interpreter.
Okay. Robert, this is a disciplinary meeting to discuss the allegations set out in your letter. I will put forward those allegations, ask you a few questions, and then you'll have the opportunity to put forward your version of events, okay? Then I'll adjourn the meeting so that I can consider all that we've discussed and anything new that you may put forward. So, do you have any questions about the process?